Hello, my name is Bridget McMahon. I'm a staff attorney at Legal Services for the Elderly, and I am a member of the York County Elder Abuse Task Force. I'd like to thank you for participating in the 2020 conference. I know the format is a little different this year, and I'm going to hope that you'll bear with me should I have any technical difficulties during this recording. Like many of you, I am working from home. And so you may hear my assistant, his name is Vegas, he likes to bark from time to time, but hopefully not. Today we're here to talk about the importance of planning for the future. And I will get this going. Okay. So again, like I said, today's topic is the importance of planning for the future, and I've put forward some tools and resources. Again, my name is Bridget McMahon. I'm with Legal Services for the Elderly. I'm going to start this conversation off a little bit with talking about legal services for the elderly and what we do and do not do, so that you understand the perspective that I'm coming up at this conversation with. All right. So Legal Services for the Elderly is a statewide nonprofit that provides free legal services for Maine socially and economically needy residents age 60 or older. And I have a link to our website right there. We operate a statewide helpline that offers assistance with numerous issues, advice or referrals to the private bar. So what advanced planning does LSE offer? So on our helpline, we offer basic planning advice and referrals to estate planning attorneys. We do not draft wills. We execute powers of attorney and advanced healthcare directives in very limited circumstances, and we'll talk about what those documents are. But those circumstances are when a client meets certain financial guidelines and when a referral to a private pro bono attorney is unavailable or for some reason impractical. So all of this is to say that we do not provide estate planning services. So today I'm not going to go into great detail on how to preserve assets by putting them in trusts or avoid estate recovery, which we will talk about if you're not familiar with. And because I'm going to leave that to the estate planning experts that are based on the individual's client's goals and assets. However, today we are going to talk about a few key planning tools. Those include DNRs or do not resuscitate orders, living wills, advanced healthcare directives, durable powers of attorney, guardianships, and conservatorships. So, like I said, I don't personally do any estate planning. However, I do regularly see the consequences of a failure to plan for the future. And those consequences can be very dire. They can include homelessness, the inability to access necessary long-term care, medical decisions that are inconsistent with an elder's wishes, financial exploitation, family members fighting for control in probate court, and a loss of autonomy. So in order to prevent those outcomes, or at least minimize them, planning is necessary. And so just a little vocabulary here to begin with. So advanced directives, it's a general term for any written or oral statement that provides instructions for what one wants to be done in the future. So it encompasses a number of documents, such as a living will, a DNR order, healthcare power of attorney, durable financial power of attorney. It's just an umbrella term for a statement of what the elder wants to have done in the future with regard to either assets or health or any of that type of thing. So a living will, it's a written document that states wishes about end of life treatment. And this document generally deals with pain management, whether or not somebody wants pain medication that may ultimately hasten their death, the level of treatment they want, whether they want artificial nutrition or tube feeding, organ donation, and funeral arrangements. It's a document that provides the elder with, or don't have to be elderly to have one of these documents, but I'm going to use the term elder, provides the elder with an opportunity to let those around them, including their family and medical professionals, know what they want to happen in the future, especially if they're unable to communicate those wishes at the time that those decisions need to be made. A DNR order, it's a do not resuscitate order. That can only be written by a doctor, and it goes into the medical chart. So usually people get a special bracelet from the doctor to signal to EMS personnel that they have a DNR order in place. You can only execute these ones with a doctor. A lawyer cannot do that for you. So if someone is interested in a DNR order, they want to talk to their medical professionals about that. A healthcare power of attorney, which is also sometimes called an advance directive, although that, as we've discussed, that's kind of an umbrella term. Healthcare power of attorney is a written document that names another person, agent, or sometimes called a proxy, to make decisions about healthcare. And that agent can be anyone that the elder chooses. So in this situation, a little bit more vocabulary, the person executing the power of attorney, giving the agent, the presumably younger or family member, authority to act on their behalf, that person is called the principal, the person executing the document. The person acting on the other's behalf is called the agent. I like to think of it very simplistically as, the principal is the boss, the agent is the employee. And this is true for advanced healthcare directives and financial powers of attorney. Anyway, so an agent or proxy can be anybody that the principal chooses. And these documents are very flexible. They can give the agent power to start making healthcare decisions right away, or reserve that power to only begin once the principal becomes incapacitated. And you're probably all fairly familiar with incapacity, and there are many definitions. We'll go through one later when speaking about guardians and conservatorships, but very generally, it's when somebody is not able legally to make or communicate their own reasonable decisions. So again, healthcare power of attorney can begin right away if you want your agent to be making decisions right away, or it can wait until incapacity. And it can include mental health decisions, the authority to make decisions about mental health treatment, and it can be as broad or as limited as the principal wants it to. This is a very flexible document that you can work with an attorney, or sometimes people don't even have an attorney. They use the Maine Medical Association form and execute it when they're at the hospital. But it can be a very flexible document, and if the individual executing it has very specific wishes, it's probably best to have an attorney draft it. So why have a healthcare power of attorney? You want this because that way the principal can designate their own medical treatment. You're not going to end up in a situation where the doctors don't know what you want to have happen if there's an emergency, a medical emergency, and you also want your family to know your wishes. It also nominates or appoints one person to be the decision maker, ideally somebody that the principal trusts, rather than take that committee approach where everybody in the family gets to weigh in and it's impossible to make a decision, and you end up possibly in probate court, which we'll talk about a little bit later. And it prompts discussion and dissemination of information about the principal's wishes for medical treatment, end-of-life care, those types of things. So without a healthcare power of attorney, who decides? And the answer is not straightforward. It is messy. Spouses can decide unless legally separated, significant others, adult children, parents, adult siblings, adult grandchildren, adult nieces and nephews, adult aunts and uncles, basically anybody the doctor can get a hold of that has a relation to the individual that some sort of medical decision needs to be made about. And not everybody wants people on this list making decisions for their health care. So that's why it's important to designate one person, or a list of people that the medical professionals can turn to, so that you're not dealing with the principal's 6 adult children and their 12 adult grandchildren, which can be a messy situation. All right, so next we'll turn to durable financial power of attorneys. And this is a written document naming another person, just like the healthcare power of attorney. That person is called an agent, to manage somebody's legal and financial affairs. And again, in this situation, it can be anyone the principal chooses. The agent can be anyone, family member, friend. Some people appoint professional fiduciaries such as lawyers, or non-lawyer fiduciaries to act on their behalf as their agents. And again, just like the healthcare power of attorney, it can start immediately or upon the person's incapacity. If the agent's power to make financial and legal decisions does not start immediately and waits until the principal is incapacitated, that's sometimes referred to as a springing power of attorney. And just like the healthcare power of attorney can be as broad or limited in scope as the principal's desires. It's a very flexible document, and it is durable, which means that it lasts beyond incapacity. So that means that the agent that you name now, who may or may not have authority to act now while you are also able to act on your own behalf, can still act after you're incapacitated, even if you're unable to communicate your wishes to that agent. So, comparing a durable financial power of attorney to a will, because they are different and people do get them confused. So a durable financial power of attorney, it expires upon death. It's only good while the principal is alive. The agent only has authority to act on behalf of the principal during the principal's lifetime. It can only be changed by revoking it. So should you want to change part of the power of attorney, even if not, the agent, the name of the agent themselves, you still have to revoke the whole document and execute a new one, which can be fairly easy. It's not onerous, depending on the changes you want to make. It helps manage your assets while you're alive. So what happens to your money, what payments are made while you are living, and it only needs to be notarized to be valid. There are specific requirements in Maine law about language that needs to be in there, certain paragraphs that are in the statute need to be included in there. So, any handwritten document that's notarized saying I want this person to be my agent is not going to qualify as a power of attorney. There are specific legal requirements. And again, that's why you want to have an attorney help you with this rather than, get some form off the internet, which may or may not comply with Maine law, because it would be not good to think you have a power of attorney, and then when it comes time to actually rely on it, it's invalid. So a will, that only commences after death. So that gives somebody, presumably a personal representative, power to administer, the affairs of the estate after death. It does nothing before you die. It can be changed more easily. Certain provisions can be altered in a codicil. And again, there are legal requirements for what that must look like and, how that must be witnessed and notarized. So that's, but it deals with the distribution of assets. So not what you want to have happen with your finances and money while you're alive, but who you want to get, any assets you had left over after you pass away. And in order to be valid, it usually must go through the probate court in some manner. So, powers of an agent. So normally an agent can spend the principal's money, cash checks, withdraw money from accounts, create accounts, sell property, including real estate, enter into contracts, pursue insurance claims or legal actions. It's a wide, broad amount of authority. Again, if you want to limit it in some way, the documents can be altered to do that. They're flexible, but you would need a professional to help with that. Limitations on agents. They must keep the principal's money separate from the principal's assets and funds. They cannot stand profit from any transaction. They must keep records and provide an accounting upon request. They cannot make gifts of the principal's assets to themselves or anyone else unless the power of attorney explicitly states otherwise. And it can have any other limitations the principal chooses. Like I said, it can be a flexible document. Safety measures. So what keeps an agent under a durable financial power of attorney from taking all the principal's money and absconding? Well, so the principal is entitled to make decisions as long as they are able. So if somebody has capacity and there is a disagreement between principal and agent as to how to deal with a certain asset, like for example, a house, principal wants to keep it, agent wants to sell it, the principal makes that decision. The agent cannot substitute their judgment on behalf of the principal. And the agent must always act as the principal would have in the principal's best interest. So they have what's called a fiduciary duty to act in the principal's best interest. And if they do not, then they could potentially be sued for violating that duty. And powers of attorney are always revocable. As long as the principal is competent and not incapacitated, they can revoke power of attorney. It's fairly easy. There's some language below. Sign, date, and notarize. and then publicize. So what that means is make it public, provide copies of the revocation to all financial institutions. If the person owns real estate, the principal owns real estate, you want to record it in the registry of deeds. And revoking powers of attorney is something that LSE does with some regularity, because as you all probably know, sometimes the authority to access somebody else's funds or assets can be a little too tempting to an agent, and it's best to revoke the power of attorney before anything too terrible happens. So who should be an agent? It needs to be somebody that the principal trusts, because this person will, assuming it's the normal broad power of attorney, this person will have access to the principal's assets and finances, bank accounts, real estate, etc. So it needs to be somebody that the principal trusts. And it needs to be somebody that respects the principal's point of view. Somebody who, if there is a disagreement between, you know, what the principal thinks should happen versus what the agent thinks should happen, somebody who can put aside sort of their view of what should happen and do what the principal wants, because that is what they are legally required to do. Is this person willing to stay in touch? You know, it's not helpful to have an agent who you can't get a hold of when you need help, or who goes missing for weeks or months at a time when they might be needed. Are they willing to do the work? Because it can be work sometimes, filling out paperwork, managing money, making sure that bills get paid, for example, if somebody is in the hospital, and keeping records of what they've done with the funds. Is this person knowledgeable about finances? It's always helpful to choose somebody who knows something about finances, because that is what a durable financial power of attorney is all about, making decisions about finances and legal matters. And so it's always helpful if the person if the agent understands what they're doing. And will this person remain calm in a crisis? Because sometimes the agent doesn't have to do anything or make any decisions until there is a crisis. And then at that point, you want somebody who can act and won't be frozen or overwhelmed with what's going on. So what happens without a durable financial power of an attorney? So in an emergency, important bills may not get paid. For example, if somebody is in the hospital and unable to pay their rent or pay their taxes or access funds, then those bills may just not get paid, and someone could lose their housing, or any variable consequence that you could think of from not paying bills, going to debt, sued by debt collectors, that type of thing. The other thing that might happen, and does happen with some regularity, is that a court may step in and appoint a guardian or a conservator, and a conservator. Just for those of you that aren't familiar, a guardian makes decisions about, it's somebody that the court appoints to make decisions about another individual. They're called the ward. Life decisions, where they live, who they see, and then if the ward also has a considerable amount of money, the court may also appoint a conservator, and that's somebody who's appointed to manage the ward's finances. Sometimes the ward doesn't have enough funds to warrant appointment of a conservator. Sometimes the guardian and the conservator are the same person, but I like to think of a conservator very simplistically as a guardian for your money. But if the court does appoint either of these positions, there is a significant loss of independence, which could include the loss of all legal ability to make decisions about your life. And the guardian or conservator may not be someone the principal chooses. It may also not be somebody the person knows. For example, sometimes the Department of Health and Human Services steps in and acts as guardian for somebody, and they don't have any sort of familial relationship with the person, but because there's nobody else to act as guardian, they have to step in. So talk a little bit more about guardianships. So they're appropriate when someone is incapacitated. And incapacity is any person that is impaired by reason of mental illness or deficiency, physical illness, disability, chronic drug use, chronic intoxication, or other cause, except minority, to the extent that the person lacks understanding and capacity to make or communicate responsible decisions. So if a principal had a power of attorney in place, a durable one, and was to become incapacitated, the agent that they named could step in to make life decisions and financial decisions on behalf of that individual. But if they don't have a document that names somebody to step in to that place when they can no longer fulfill it, then that's when you have to go to court. So that's why getting a power of attorney can sometimes, or the idea is that it would prevent having to go to court, possibly losing all the principal's rights, and also having some sort of court battle, ending up with somebody you don't want or don't know as your guardian, making life decisions. Those are all outcomes that people generally do not want. So just to compare a durable financial power of attorney to guardianship and conservatorship, the durable financial power of attorney, the principal retains legal authority. They get to make those decisions as long as they have capacity to make those decisions. Even if the agent does not agree with those decisions, the agent is nonetheless obligated to carry them out. I often hear that somebody has power over somebody as a power of attorney, but that is actually sort of the opposite of what a power of attorney is intended to do. I mean, it indeed gives an agent authority to act on behalf of the principal, but only in the way that the principal directs the agent to act, or that the agent believes the principal would want them to act should the principal be incapacitated, and always in the principal's best interest. Like I said, the agent must do as the principal wishes, and there's no substituting judgment. The agent can't say, oh, that's a bad idea, we're going to do this instead. The principal is the one who makes the decision. With a guardianship or conservatorship, the ward has no legal authority. They can't make decisions. The guardian or conservatorship must act in the ward's best interest, and the ward's wishes are only advisory. I mean, they can take them into consideration, but ultimately the guardian or conservatorship has the final word. And it requires substituted judgment. I have heard guardianship referred to as civil death, because a full guardianship, you lose pretty much all of your civil rights, the rights to make decisions about your life and where you live and who you speak with and what you do. So a lot of people want to avoid that, and having a durable financial power of attorney with an agent who is trustworthy and able to act in your stead when you do become incapacitated often prevents the need to go to court and have a guardianship and have those rights taken away. So now I want to talk about some self-planning tools, which we see pretty often, in addition to sort of the consequences of not having those planning documents that we discussed earlier. A lot of times we see people who do self-planning, and there are two major things that I see at LSE over and over again, which are often not a good idea, but are very, very common. The first is naming a family member as joint owner on a bank or financial account. And the second is transferring real estate to friends or family to avoid Maine care estate recovery. So we'll start with the joint ownership issue. So if an elder names somebody else as a joint owner of the account, that joint owner has unrestricted access to all of those funds. From the financial institution's perspective, that person is just as much an owner of all of the money in that account as the elder, regardless of whether the joint owner contributed any of that money. It may entirely be from the funds of the elder, but if they are a joint owner, they are entitled to all of it, just as the elder is. Another real potential is that the principal's money could get caught up in the joint owner's legal battle. So let's say an elderly woman names her adult child, her daughter, puts her on the joint account as joint owner, and daughter is sued, and daughter's assets are frozen. Well, those assets would include the account with the mother's name on it as well. If any accounts that that joint owner's name is on could potentially be frozen or garnished, which is usually not the intention of the person putting somebody's name as a joint owner. Usually it's just so that that person can help them manage their money and access it. But the power of attorney document does that in a way where you avoid these risks. You have, as an agent, there's a fiduciary duty not to misuse the money. And because the agent is not an owner of the account is not going to be frozen or garnished because of some legal battle that the agent is in. And the other thing is that if somebody is a joint owner on an account, they will get all of the money when the principal dies, regardless of whether there's a will that says, oh, I want all of this money in account to go to my wife. Well, if your son's name is on the account with you, your son's getting it all regardless of what your will says. And unfortunately, that there are people who aren't going to hand over the money to somebody else. Real estate transfers. Okay, this is another big one we see over and over again. That's when an elder transfers real estate to a family member. A lot of times it's an adult child in an attempt to avoid estate recovery. So very, very simplistically, and of course there are nuances with all of this, but estate recovery is when somebody has applied for long-term care, Maine care, and the state has paid for long-term care services while that person was alive. Once that person passes away, the state is entitled to recoup what it can from the individual's estate. So, a lot of times I see people who their only asset upon death is their home. So the state of Maine estate recovery unit will make a claim on the home for in the amount of the value of the care that the state provided during that person's lifetime. And so if the individual had wished for, this house to go to their child would have to pay that off before, getting the house. So in order to avoid all of this, people transfer houses, property, those types of things to their children most often. But this is very, very risky because it could limit access to necessary medical care during the 5-year look-back period. So again, very simplistically, the look-back period is 5 years before anybody applies for long-term care, Maine care. If they've given away any assets or transferred them for less than fair market value, there will be imposed a penalty. So when somebody applies for long-term care, the long-term care department at Health and Human Services will go back through their bank records and list of their assets and what happened to this, what happened to this. You had a house, where did that go? And if the answer is I gave it away, then they'll say, well, then we're not going to pay for your care until you've paid that much. So for example, if they gave away a $200,000 house to their child, adult child, they would get a $200,000 transfer penalty, meaning Maine Care would not pay for their care until they've paid $200,000 out first. And again, that's a very simplistic definition or explanation of that, but that's generally, very generally what happens, and it's a real risk because then people can't get the care that they need. Another real risk that we see over and over again is that somebody ends up being displaced from the home or homeless. They give the house to their child, that child for whatever reason decides that they want the whole thing to be theirs, and then that elder is just out of luck and may end up being homeless, especially if their plan had been to reside in that house and they gave it away. And a lot of people say, I never expected my son or daughter, insert family member, to do this to me, but people change, living situations change, new people come into their lives, and all of this can affect, whether, the relationship between the two people, and a loss of control over the property. So if an elder deeds the property to their child with the idea that, well, I'm going to continue to live here for the rest of my life, and I'm going to be here just like I was before, well, if you haven't taken any precautions or any measures to protect yourself, which we'll talk about a little bit, then you no longer make the decisions about the property. And so those are the risks, some of them. I'm sure there's always more than we can all anticipate, but those are the big risks that I've seen a number of times. But this type of transaction can be made at least a little safer with the assistance of an attorney that specializes in estate planning. That attorney can help the elder reserve a life estate or a life lease which would prevent displacement from the property, giving the elder a right to continue to remain there even while they've transferred, ownership of the property to somebody else. They can also help the parties come to a clear agreement about their relative financial obligations, because an elder may think, I'm transferring this property to my child, they're going to end up with it, I'm assuming they're going to make the mortgage payment. Well, that may not be the child's assumption, and these are things that need to be talked about and ideally put down on paper ahead of time. Who pays the utilities, who pays heat, who pays for lawn care, snow plowing, property taxes, all of those things, they need to be discussed ahead of time. And an attorney can ensure that there is some plan for how to pay for care during the look-back period if there is a transfer penalty imposed, because nobody knows what the future holds. Somebody may be very healthy today, but be in a car accident next year and require long-term care, and you don't want to be in a position where you need to be in a long-term care facility, but you can't get that care because you can't afford it and you gave away your only assets. So what I am hoping you'll take away from today is that appropriate planning for the future promotes autonomy and ensures that an elder's wishes are carried out. I've heard, this is kind of a corny saying, but if you fail to plan, you plan to fail. So, planning through the documents that I've talked about is really, really necessary, because otherwise you may lose control over all of the decisions in your life should something horrible happen and you become incapacitated. The other takeaway I am hoping you will get is that self-planning is risky, and that if an asset is worth preserving, if it's worth passing down to your children, it is worth the cost of hiring a professional to do it right. And even though LSE does not do this type of planning, we can do some minimal advice over the helpline, which may be, you need to speak with an estate planning specialist, and we can help with referrals there. Sometimes those referrals, especially for durable financial powers of attorney, can be a reduced fee, or sometimes pro bono referrals, depending on how much money and assets the individual has. So it is worth calling us, even though we don't do this specific work. And at the very least, we can give you the names of some attorneys in your area that do this type of work and can help you. And that brings us all the way back to LSE's contact information. So please feel free to give this out to your clients or your patients, or whomever you work with. I'm assuming that most of you work with some sort of elderly population. And it's important that if that person has questions, that they give us a call. They need to call, not a family member, unless that family member is already an agent under a valid, durable financial power of attorney. But they can call with the help of somebody else, with the help of a family member, with your help, just to get sort of a breadcrumb trail of where to go from whatever issue they're having. Okay. Well, that's all I have today. Thank you for listening to me drone on for what feels like quite a while. And I am happy to take any questions. if you want to send them to the York County Elder Abuse Task Force. Obviously, I can't give out legal advice for somebody's specific situation, but a lot of times my recommendation will be call our helpline. And again, that number is 1-800-750-5353. Thank you all.